Hello everyone, welcome back to another episode of Ask Prashanthi. I'm your host Prashanthi Reddy. I'm an immigration attorney and I'm dedicated to helping you navigate the sometimes challenging and often rewarding world of US immigration law. In this show, we tackle your questions and your pressing concerns that you have about visas or green cards, citizenships, or anything else in between. We pull questions from our channels on YouTube, LinkedIn, Facebook, Instagram, and of course, those excellent questions that you ask on the website. So if you have a pressing question, make sure you submit it. You will hear from us in the next episode. Now let's go to the questions. The first question is from Sasha, and this was posted on my website. And Sasha asks, if the I-751 is denied and I don't receive the letter on time to file a response, and the time for refiling has expired, what are my options? So first of all, you have a 90-day window, as you might know, before the expiry of your temporary green card to file the I-751. So you have to file it within that period. And if for some reason it gets denied and you're still within that window, you can, of course, go ahead and refile your I-751 and try to overcome those issues that you faced last time. However, if the response comes after the 90-day window, then you can still refile your I-751 and you should, but you have to give reasons, a request as to why the late filing should be excused, and a written explanation showing that your failure to file on time was for good cause and due to some extenuating circumstances that were out of your control. This is basically called a nunc-pro-tunc filing. And once you send this request and with this explanation as to the reason for the delayed filing, then USCIS will determine whether there was a good cause or not, and if the failure to file on time was outside of your control. I hope that answers your question. My next question is from Surabhi, and this question also was posted on my website. Hi, is a H-1B transferable if extension is in progress with current employer? So Surabhi wants to find out if she can transfer her H-1B while the extension is still pending through the present employer. Yes, you could. It would be a bridge petition, and you would file the transfer based on the pending petition that is filed based on the pending extension. You would put in that receipt. This is provided that your I-94 is already expired. Of course, if your I-94 is not expired, then there's no issue. You can just go ahead and file a petition for a transfer based on your I-94. But if your I-94 is expired, then you would have to use the receipt and then it would become a bridging petition. In this circumstance, USCIS could either approve the petition or they could ask for proof of approval of your underlying extension petition. So that they might ask for an approval copy in order to proceed further. They would typically do this in an RFE. They would send an RFE. So I suggest that you premium process your underlying H-1B extension petition so that you'll be able to get the approval quickly and provide them the approval in the RFE. And an RFE, usually they give you 85 days to respond to it, so you have some time to get the approval in the meantime. I hope that answers your question. Okay, now let's go to question number 3. Question number 3 is from Dinesh, and this is also posted on my website. Dinesh asks, in a situation where there's an F1 student who's currently in post-completion OPT and applied for STEM OPT, now he has 2 more years left on STEM OPT, but he got picked in the H-1B lottery. In this case, can he now apply for counselor processing for the H-1 and start his H-1 once his OPT ends? In this case of applying for counselor processing, can he change the employer after getting H-1B approval? Pros and cons. To answer this question, yes, you can apply for H-1 counselor processing. That way you can continue on your F1 status, and after the completion of your F1 status, you can then go for a visa on your approved H1 and then come in on a H-1B to get into a H-1B status. The problem with this is if you file the H1 now and it gets approved now, and you go for a visa 2 years later, at the consulate they will ask as to why you did not come for a visa earlier, why you didn't start working for the employer earlier, and so the employer has to provide responses and has to give the reasons as to why there was a delay of 2 years in the start of the project or start of employment. To answer your second question as to whether H-1B employer can be changed, yes, again, the H-1B employer can be changed since you were previously approved under the cap and you was already counted towards the cap. You can file another H1 as a cap exempt H1 and you'll have to file it. You can file it change of status at this point, or you can file consular processing, whichever you choose. This is, of course, based on the current regulations. H-1B cap, who is subject and who is not, that keeps changing. They keep changing the interpretation. But as of now, it's a pretty liberal interpretation. And as long as you have been approved for a H1, you are not subject to the cap again. You don't have to go through the process again. Coming to the fourth question, this is from Satya, and this is also posted on the website. On my website. I have a H-1B extension query. I'm planning to upgrade my I-140 application to premium. Also, I want to travel to India early next year. I have a current validity of October 2025. Can I apply for an extension 6 months prior to expiry? I need to go for stamping and want to get stamped for extended period. Yes, absolutely. You can apply for your H-1B 6 months ahead of time. You can apply more than 6 months ahead, but you can apply anytime from 6 months to the day before your status is expiring. I hope that answers your question. The next question is from Anita, and this is also from my website. I-130 filed by father on behalf of the daughter, and it's approved. However, the father expired post I-130 approval. A reinstate petition was filed by US citizen sibling and currently under review by USCIS. What are the chances of reinstatement, and will the original priority date be retained, or will it have to start from the date when the sibling-based new petition was received by USCIS? So to answer your question, yes, the priority date can be retained, but you have to request for the priority date to be transferred from the previous I-130 petition to this particular I-130 petition. Reinstate also can be approved, and even if they don't approve it, you can file a new I-130 petition, sibling-based, and ask for the priority date to be transferred. But another thing to keep in mind is that as of 2009, there is a new law which Congress enacted, which allows you to continue your I-130 petition and adjustment even after the sponsor has passed away. And I'm not sure whether you're aware of this, but this provision allows you to do so as long as the applicant resides in the US when the father died, the qualifying relative died, and the applicant continues to reside in the US on the date of the decision on the pending application, and the applicant is, it's a family-based case, which it is right now. So you meet that criteria, and as long as you meet the residence criteria, you can continue and file for adjustment of status even though the father has expired. So this is something to keep in mind, but of course the person should be in the US to qualify for this. And with that, that brings us to an end of another episode of Ask Prashanthi. I hope the questions we answered were useful for you today. And remember, understanding your options is the first step, but reliable information is key. So if you have a question that you want answered on the next show, don't hesitate to reach out. You can leave a comment on your YouTube channel, connect with us via LinkedIn or Facebook, or submit the question directly on the website. Please follow the link in the description. Thank you. See you next week.